Hello and welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments which have taken place in the last few weeks in the realm of domestic taxation. We have selected 3 important cases for you. The first one deals with the extension sought for compliance of income declaration scheme. The second one is about the denial of refund for delayed act of taxpayer's auditor. And the last one deals with the taxation of shares held by a trust in fiduciary capacity as its business income. The taxpayer is an individual who sought an extension of time for compliance with the income declaration scheme. Now let's understand what exactly happened in this decision.
Now let's understand what exactly happened in this decision. In the instant case, the assessee had applied to the competent authority by making necessary declaration under the income declaration scheme of 2016. However, she failed to comply with the procedure and conveyed to the CBDT that due to medical complications and unavoidable circumstances, she could not deposit the first installment of tax payment within the stipulated time frame. She therefore requested for continuation of delay. Since there was no response to her plea, the assessee approached the High Court and pursuant to the decisions of the court, the CBDT passed an order rejecting the application of the assessee on the ground that further relaxation under the IDS would demotivate honest taxpayers who were paying taxes promptly.
Let's see what was the final outcome in this case. If the legislature has framed a special scheme giving certain concession to assessees who had till then not declared their incomes truly and fully, it can always lay down limits of such concession.
Here are the key takeaways. Declarant under the scheme cannot seek continuation of delay while paying installments of tax on the undisclosed income if reasons for continuation are attributable to the taxpayer. The CBDT recognized the limited area for relaxation in favor of declarant where though the payment was made within time, but the bank had not credited the same in the government account.
Now let's move on to our second case, where the High Court was approached to intervene and issue directions to the department to process refund application of the assessee, which was delayed because of his auditor's act.
Now let's understand what exactly happened in this decision. In the instant case, the assessee, while filing its return, had omitted to claim TDS and as an adjustment or for the purpose of consequent refund. The assessee paid the amount due in terms of its calculation. Consequently, the assessment was framed and the period for revising the demands ended. However, the error that had crept in while furnishing the returns was not rectified through an application or a refund undertaken. Later on, upon noticing such an error, the assessee applied to the jurisdictional CCIT for condoning the delay for filing application for refund. In its application, the assessee claimed that its CA had inadvertently overlooked the TDS amounts, and as a consequence, it could not have sought appropriate refund at the first instance. The application was, however, rejected on grounds of being not backed by substantial evidence.
Let's see what was the final outcome of the High Court. The application for refund cannot be rejected if filed belatedly due to inadvertent errors made by the claimant's auditor.
Here are the key takeaways. A taxpayer's claim of inadvertent mistake committed by his auditor in overlooking TDS amount has to be characterized as bona fide, as no one will deliberately wish to forego his money. Wherever the legislature intends relief against hardship in cases where such statutes lead to hardships, the authorities concerned have to construe them in a reasonable manner. Now let's move to our last case, where the proceeds held by a trust in its fiduciary capacity were sought to be taxed as business income.
Now let's understand what exactly happened in this case. The assessee in the instant case is a trust created by the employer for the welfare of employees of the settler company. The activities of the trust include investing in equity shares and to administer the fund as instructed by the compensation committee for benefit of eligible employees. One such benefit included the right to choose employees stock option scheme. It was noted by the AO that several employees had exercised such option and the trust had allotted shares to those employees in terms of their options. The proceeds received from the employees were recognized by the trust as revenue receipt and shown as its long-term capital gains. The AO, however, held that the same should be taxed as the trust's business income. The matter ultimately reached the tribunal, where it was held that the SSC trust was holding shares in their fiduciary capacity and hence the proceeds could not be taxed as business income.
Let's see what the final outcome of High Court was. When a trust holds shares in the fiduciary capacity and acts as special purpose vehicle of the settler company, then proceeds from sale of such shares cannot be treated as trust's business income. Here are the key takeaways. A trust acting as an extended arm of the settler company and not holding the shares in its own absolute right is not liable to tax for the income generated from the transfer of such shares. If the trust is not authorized to sell the shares held by it on behalf of the settler company, then it cannot be construed as share trader. Hence, shares held by such trust cannot be categorized as its stock in trade.
With this, we wrap up this episode of Legal Wrangle. Please stay tuned to tioltube.com for our upcoming videos. Please also feel free to share your views with us at editor@tiol.in. Thank you for watching. Goodbye.